Yes, my dear brothers and sisters, this is Advocate B. Murari talking to you from Ahmedabad city, which is a state India, that is our Bharat. Today I have selected a very useful and knowledgeable topic from civil law, and the name of the topic is Inherent Power of Court. Under section 151 of Civil Procedure Code 1908. I think this is the first video of its kind, and this is useful to all throughout the country. I'll read out section 151. Saving of inherent powers of court. Nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of the court. Two things. For the ends of justice or to prevent abuse of the process of the court. And now let us make legal analysis of this. Power must be exercised sparingly and in exceptional cases only as a last resort. Citation, 1973 Kerala 1, full bench judgment. Exercise of the power must be consistent with the sound general principles of law and with the intention of the legislature. Inherent power shall be exercised in accordance with justice, equity, and good conscience. It means inherent power can be used when the ends of justice and equity so demand. The primary duty of the court is to see that truth is arrived at. Order under section 151 CPC can be passed for doing complete justice to the parties to the suit, means plaintiff as well as defendant. If the discretion is exercised by suppression or concealment, the same must be withdrawn and the benefit recalled. It means person seeking order under section 151 must come with the clean hands before the court. Inherent power cannot be exercised to strike out defense. Inherent power cannot touch defense, and also cannot be exercised to enable a party to evade the law of limitation. The law of limitation, if it is applicable to defendant, then by using power under section 151, cannot be deleted. It cannot be used to set aside finding given by revenue court on a matter within its exclusive jurisdiction. It cannot be used to reopen settled matters. One of the first and the highest duties of all court is to take care that the act of the court does no injury to any of the shooters, and when the expression act of the court is used, it does not mean merely the act of the primary court or of any intermediate court of appeal, but the act of the court as a whole, from the lowest court which entertains jurisdiction over the matters up to the highest court, apex court, is finally disposed of the case. So, act of the court prejudices none. Order 39, rules 1 and 2, and section 151 of CPC. Section 151 of the code confers power upon the court to grant injunction if the matter is not covered by rules 1 and 2 of Order 39 of the code. 1962 SC 527. Court cannot override express provisions of law. Relief under section 151 can be granted only when grant of relief is not prohibited under any provision. Whether there is a specific prohibition of a particular act or order, the court cannot do the act or make the order unless under its inherent power. Inherent power cannot be utilized by a court to reverse its earlier order on the sole ground that it is later found to be erroneous on merit. Court, under its inherent powers under Section 151 of CPC, can receive the document required for the effective adjudication of the suit in the absence of any express prohibition to that effect in the civil PC. Year 2003, AP 282, Andhra Pradesh 282. But cannot under its inherent power restore a suit. Court can, under its inherent power, restore a suit dismissed under Order 7, Rule 11C, if good cause is shown. When the trial court found on the basis of material placed before it that at the time when the plaintiff has filed his case by the plaintiff was not in possession, and the dispossessed the defendant after filing the suit. If the trial court passed an order, interim order, restoring back possession to defendant, it cannot be said that it has committed jurisdictional error or material irregularity. Here is the due course of law. Process of the law should be followed. By force, no one can be dispossessed. 1997 AIRC 3681 Ras. The civil court, in exercise of its inherent power under Section 151, can certainly allow police help, when police help can be given, to a party for implementing the order of temporary injunction in deserving cases. But at the same time, parties seeking police help must state reasons for such help in its petition and certify to court that there existed a state of grave emergency required police help. Year 1993, Andhra Pradesh 103. The court has power under Section 151 to assign or modify the stay order by it under that provision. Year 1997, Madhya Pradesh 37. It will not be in the hands of justice to assist a party guilty of laches, in consequences of which new rights have arisen against him. Year 1975, Orissa 184. Court cannot, even for the purpose of securing the ends of justice, travel outside the jurisdiction given to it. It has to act within limit. The court has ample jurisdiction under Section 151 to order restoration of possession when a party has been forcibly dispossessed. 2000 AFC 3301 Rajasthan. When unlawful means are adopted by a party, it is responsibility of the court to invoke Section 151 CPC to secure the ends of justice or to prevent abuse of process of court. Therefore, when party entered into possession by violating injunction order, it is the duty of the court to restore possession by taking recourse to its inherent powers. Year 1992, Kerala 373. Where another remedy is provided for a party who does not resort to that remedy, cannot invoke the inherent power of the court to obtain that remedy. Year 2002, Bombay 487. Inherent power does not extend to correction of an erroneous view of law. Year 1984, Andhra Pradesh 352. Now, due diligence. Though there is no limitation for applying under Section 151, the party invoking inherent jurisdiction has to be diligent and also should not be guilty of laches. Party should be diligent and should not be guilty of laches. Year 1974, Patna 289. The court has no power to amend decree in material particulars under Section 151. Decree cannot be amended by the court. Year 1996, SC 3323. Disobedience of injunction order. Party agreed can seek relief under Section 151, AIR 1986, Kerala 63. Now, the abuse of process of God, the meaning of it. In the law of lexicon, the words abuse of power, process of God are defined as follows. Abuse of process of God is a malicious and improper use of some regular legal proceedings to attain an unfair advantage over the opponent. Nothing short of obvious fraud on the part of a debtor would render him liable to have his petition for insolvency dismissed on the ground of abuse of process of God. The term is generally used in connection with action or using some process of the court maliciously to the injury of another person. It is also abuse of the process of the court. It is only in case where the proceedings are fraud, vexatious, or want of bona fide, malicious, and improper, then it comes within the meaning of abuse of the process of the court. Citation M.V. Rajsekhar versus M.V. Rajamma, year 2004, Karnataka 280. Well, this is the end of the video. Hope you have got some useful information, and see you in the next video. Thanks for patient hearing. Thanks for being with us. Thank you, thank you, thank you. Shri Krishna Saranam.